Karla Gilbride's argument was flat out fantastic. It is one of the best oral arguments I've ever seen in the Supreme Court. She had the most important points right at her fingertips. She had a complete command of all of the case law, so she had a command of all the law. She had a complete command of the facts. She knew a very complicated set of laws from federal courts, from state courts, from cases in the 1800s to cases decided a few months ago throughout the country. It was really a tour de force, and I think I think it was one of the best oral arguments that I've seen in the Supreme Court, in having seen more than 100 of them over 20 years.
Mr. Chief Justice, and may it please the Court, Section 2 of the Federal Arbitration Act requires that an agreement to arbitrate be enforced unless a generally applicable contract defense renders it unenforceable. But the Eighth Circuit didn't apply a generally applicable contract defense here. It applied an arbitration-specific waiver defense that requires the person asserting waiver to prove prejudice, even though prejudice isn't required to establish waiver of other contractual rights in Iowa. That's what the Eighth Circuit did wrong, and that's why we're here. It should have assessed Robin Morgan's waiver defense under generally applicable Iowa law to determine if there was an enforceable contract on which the procedural provisions of the FAA could operate. If it found waiver under state law, that would have been the end of the inquiry. Sundance intentionally relinquished its contractual arbitration rights by asking a federal judge to dismiss this case and filing an answer that didn't mention arbitration. Those actions should have been sufficient for a finding of waiver, and the same actions placed Sundance in default within the meaning of Section 3. Prejudice has no part to play in either of these inquiries, and the Eighth Circuit was wrong to require it.